My name is Kabelo Letebele. I am the Senior Manager responsible for communications and stakeholder relations within the Legal Practice Council. I want to take this opportunity to welcome you to this conveyancing exams prep session and the notarial exam prep session. Thank you for taking time. I am sure you're going to find the session informative and useful for the exam that you are preparing for. Before I go to the first presenter, I want to point out and remind you that this session is being recorded and we will make the recording available on the LPC YouTube channel. If you have not seen the syllabus, please visit the LPC website to see the syllabus for these exams. And we will do our best to ensure that by Monday, the recording of this session is made available. We also encourage you to follow the LPC on social media, particularly our Facebook page and X. Some of us still refer to it as Twitter, but X, please do follow us there because we do make a lot of announcements. We do give a lot of updates and share information on those platforms. Without further ado, I would now like to hand over to Mr. Tumelo Mahwai to take us through the conveyancing examination preparation. Mr. Mahwai, over to you, sir.
Thank you, sir. Good day, everyone. Good day, colleagues. Generally, the sessions, at least the conveyancing part, takes about 30 minutes. Let's get going. Some of the, just remember, if you are to check whether you are duly registered and that you have the confirmation as to the center where you are writing. Okay. All right. This purpose of this session is effectively to give a broad guideline on how you can prepare yourself, taking into account a perspective from us as examiners and as drafters. So we're going to give you a bit of an insight as to how we come to think about the scripts as they come in front of us, and how we go about drafting the questions to an extent, and what the thinking is, and hopefully that can help you. But we do find there is a large number of the candidates that write the paper, the conveyancing paper particularly, that they fail not because of inability to draft documents or lack of knowledge, particularly when it comes to the paper 2, the drafting paper. We find that there's unnecessary minor errors that could be simply because of not understanding what we expect from, or what the examiners expect from candidates. As you know, the paper has now been divided into 2 parts, in that it's divided in days of writing. That gives you a lot more opportunity to study and give you a brief of what to focus on one, and then in the coming week to focus on the other. The dates are there. I'm sure you're aware. If you are in this session, you should know the dates by now. The 2 papers, okay, before we get to the 2 papers, the paper as drafted, it will be as per the circulars and amendment up to the end of 2024. However, if you implement or apply the 2025 amendments, such as Regulation 30, you won't be penalized, but the rule is in line with the syllabus. We will mark, the paper has been drafted up to the legislative amendments and circulars of end of 2024. With the paper 1, it's more a theory paper, as you're aware, and paper 2, it's more drafting. When you come down to your paper 2, you need to draft. And then when you get to your paper 1, that is effectively similar to paper 3 in the attorney's exam, where you need to study as much of your contract law, company law, trust law, deeds practice in general, but it's more in theory, very little drafting. One of the things that you will almost always find in paper 1 will almost always relate to agreements, contracts, such suspensive conditions, companies, such as things such as resolution. Familiarize yourself with those, and legal capacity in all its forms, whether a natural person, and if it's a natural person, whether it's a minor, and in the case of a minor, whether Section 80s are going to be applicable. When it comes to marriages, the appreciation in all its forms, the Section 15 of the Matrimonial Property Act, in case of a marriage in community of property, the differences when it comes to the type of transaction where consent is required, where consent can be ratified. It is important that you familiarize yourself with those nuances. Effectively, make sure that you don't go into that paper 1 without knowing the legal capacities in all its forms. Okay? But I'm not limiting the scope there, but generally candidates get that wrong. And we have also tended to move towards specific resolutions, and mainly important resolutions, that is conference resolutions and the circulars. It is important that you acquaint yourself with what are the common resolutions that are applied in the deeds office and circulars, and familiarize yourself. You will find most questions out of that paper 1, are direct questions from circulars and conference resolutions. Syllabus, I'm sure you have now all downloaded the syllabus. It's available on the LPC website. The rules as you get into the exam, please, if you're too nervous to study what you must do, how you must do it with each exam, the rules, please familiarize yourself. As we said, short summary, effectively what paper 1 entails. We've already discussed that. Sometimes the little drafting that you might get a bit of extending clause, because that seems to plague most candidates, and a bit of causas, you might find a bit of those. Usually the drafting is very limited. And when you are asked generally on specific sections and you do not know the section, or you're unsure about the section, it is best that you not refer to the section instead of guessing a section and getting it wrong. If you get the principle and the idea correct, you will most probably get the full marks. You will not be penalized generally for not referring to a resolution or a conference resolution or a chief registrar circular or a specific section. But if you have a general understanding, you will most of the time get the full marks. Similarly, when you're drafting in paper 2, if at the heading of, let's say, your application in terms of section 4.1b or section 3.1v, and you forget for some reason under the high pressure of exams, you happen to forget the section, rather leave it out, you lose 1 or 2 marks. If your content is fully correct, most likely you will only be penalized for those 2 or 3 marks. You will not lose your entire marks. We generally focus on your substance. Okay. Again, this needs no repetition. Your pass mark, keep in mind as a rule, although the pass mark is 50, the examiners have a discretion to call you in for an oral exam, even if you've gotten 50%, but I've been doing this for the past 12 years or so. I have not seen one done, but it can happen. It's within the rules. Okay. So one of the most important section, and quoting this, one of the most important legislations that you must know effectively by heart without necessarily knowing the section, but you must know Deeds Registries Act and Sectional Titles Act. This is in no way trying to limit the scope, but it is important to know the Deeds Registries Act, the Sectional Titles Act, all the necessary forms. If you do not know the forms and you have to look for the forms in the exam room, you will not finish writing this exam. Study them beforehand, memorize the forms, where they are, what they are applicable to beforehand, so that they are just going to, when you have the forms in front of you and the act in front of you, it's just to guide you so that you follow the correct form in its right format. Once you know the act, the next thing is familiarize yourself with the practice and procedures and the norms and standards that are applied in practice. Generally, you'll find this through some notes, wherever you get your notes from, and you will get through from textbooks. There's some prescribed material that are available on the syllabus, and circulars and resolutions. When we're referring to circulars, we mainly referring to not the local circulars, but the chief registrar's circulars and resolutions. We generally do not ask about or on local circulars from one specific deeds office, because local deeds practices differ. As this is a national exam, we will ask those that are applicable, the circulars and resolution that are applicable at a national level. The numeracy and accountancy, and please remember on paper 2 to bring your calculator. There will almost always be an accounting question paper, whether it be the statement or a guarantee in one form or the other. Please, when you find a statement or a guarantee, start with your statement. Even if it's at the end, if you find it, start with, that's effectively your easiest marks that you can get. Most mistakes are done because the candidates do not finish drafting or don't even get to. And most of the time, your statement accounts for about 25 marks to 30 marks, which is effectively 10 to 15% of your total paper. If you can get that for free, then why not? Start with that statement of account. If you do not know the difference between debit and credit, you do not belong into the exam. But most of you as colleagues, you know the differences. Most of you are practitioners in your own right. You run successful practices. Start with your account. If it's a guarantee, start with that. It's just number crunching. You get the numbers right. You get your 10 to 15% of your marks. Then you can move to the other drafting. We are with colleagues on the drafting side. We are moving more and more, particularly on the paper 1, on the responsibility and ethical sides. Okay, you will see that we have quoted a couple of cases on the syllabus, more in particular Margalit, because it's becoming a plague to the profession, that there's some ethical standards that are not adhered to, so they will almost always, at least from the recent times and going forward, it's some ethical questions, special and recent case law. And that last point on the slide there that says showcase your ability to execute conveyancing instruction. This is particularly important in that if you're given a set of facts, do not contradict or move away from the facts given. If you have to invent your own facts, make sure that the facts that are given on your question paper are followed strictly. Over and above the two main acts, effectively the Deeds and Registries Act and Sectional Titles Act, don't lose sight of other important legislation such as the Alienation of Land Act that are almost secondary to those, but they remain crucial. For example, if you do not appreciate the consequence of Section 2 of Alienation of Land Act, which is very important when sale of land is involved, you're going to struggle in this exam. And when you approach your question paper, and don't just look at it as a question that is presented by examiners. See it as clients in front of you that are going to ask, that come with those set of circumstances, and then look to solve a problem in as real world as possible. Because the clients, they come to you, when they come to you, they will not say, I've made a spelling mistake on my ID and that, or I've made a spelling mistake on my ID. I've changed my ID. Please draft for me a Section 93 application. They will say, I've made a mistake on my ID. I've changed my ID. Can you update my title deed? Is it possible? Then you implement from there. So we try to then ask questions as if they are real world instructions from clients, unknowing clients. Here again is just a quote, and because of the importance of Magalit and the Supreme Court highlighted that your mistakes, while a mistake can happen, the test is then to check whether that mistake that you've made can be equated to negligence. If it equated to negligence, as was the case in Magalit, you are going to be held liable in your personal capacity, and that you are bringing the law into disrepute. Thank for small messes. In another case where Magalit was quoted, in that Ninaba case, the attorney was found to have honored their duties, did not fail in exercising their duties of care towards the client. You can read it for interest, but it was an example where things go wrong, but a conveyancer did their part. Now, we're going to get to the nitty-gritty and a bit of details which I find necessary to highlight. And because from a examination point of view and the instruction given to all of us as examiners and to all examiners is treat every script that you receive as a deed that is executed for registration. Treat it as a real world deed that should pass the tier of examination, all the three tier levels of examination in the deeds office to pass for registration. With that in mind, then we look at the act itself, what it says about how documents must be drafted. We look at the circulars and resolutions. We've quoted there the CRC 1, for example, which effectively says trial and error is not allowed. You can't do a test lodgement, as they call it, where you lodge and see what the deeds office throws out. The deeds office actually is entitled to reject your deeds at one go, in my view. Hence, they've now even implemented a fee for every lodgement, which is prejudice to those that don't get the rejection. If one colleague keeps carrying rejection, the other colleagues keeps paying that 50 rand because of lodgements now. So that is emphasized in that all circular that says trial and error is not allowed. So don't do a trial and error in your exams. I know it's a quite an intense exam, and generally we are confronted with ideas and sentiment that, I mean, a candidate just made a small error on the name. We are petty, or the examiners are petty. But then when you look at specifically when the practice and the resolution, for example, that is quoted there of 1954, which is still in play and still applicable, says minor errors on names, minor discrepancies on names and ID numbers, it's a reason for rejection. And that is important because in the days now, it's even more important today that we have a lot of identity thefts. So the integrity of the information with the register, it's quite important. There's that old resolution is a bit outdated of 1961, CRC 1 of 1961, gives you a common list of things that may be things that are grounds for rejections, quite a longish list. Go through it as well. There's a couple of outdated things. You're going to have to read them out of that are no longer applicable, but go through that. And those errors that are justifying rejections there, those are the same errors that are likely to be in your exam papers. That, for example, that CRC2 of 2009, it's another important, especially the first part and the last part about the general. There's a paragraph 2 and paragraph, and I think it's paragraph 5 on that circular, which effectively deals with some minor issues such as use a black pen when you draft your deeds. And if you know the regulations, regulation 20 subsection 8 says the registrar may exercise a discretion when it comes to non-comply with what is provided for under section 20, subsection 1 up to sub-regulation 1 up to regulation 7. It deals with ink, durability of paper, neatness, and so on. Such might exercise a discretion. But then that circular 2 of 2009 says that discretion is limited only to documents that are not drafted by the conveyancer. If it's a clearance certificate that is drafted by the municipality or a homeowners association, or a consent that is given by a homeowners association that does not comply with the rules, the discretion is afforded there. Although the regulation says the registrar may exercise a discretion, that circular 2 of 2009 limits the discretion to documents that are not drafted by a conveyancer. See your paper in that light. With all that strictness that sounds so scary there and rigid rules, we understand the time constraints that you go through. Most of even some prescribed documents, there is an allowance in practice to allow a bit of adjustment as long as there is no substantial contradiction to the prescribed form. If you've made the necessary adjustment because you think they are necessary, you will not be punished for that. What is, however, not acceptable, where we are generally rigid on, is on statements of account errors in a calculation, because they commonly lead to trust shortage. But the conveyancers, the examiners are conveyancers, qualified conveyancers. As a rule, I believe an examiner is not allowed to participate in the examination process unless they have at least 7 years experience. Again, here we reiterate that it is not, if you're asked a question that relate to a specific section and you know about it, you know, and you're certain of it, and you're certain of the circular, you can mention it there. But the fact that you don't mention the specific circular or the legislation or the section in the regulation, you will not be penalized as long as there is substantial understanding, unless you're specifically asked, which is very uncommon that you be asked to be expected to mention a specific circular or a section. Now, in general drafting, we've gotten the idea what is expected. Now, let's look at some of the basics. When you draft your deed that is for registration in the deeds office, the first thing you start with, and we still get 50% of the candidates that do not know how to do a prep clause that is going to be signed by a conveyancer. Keep in mind, it is not necessary to sign your prep clause. That's not necessary. Whether you sign or not sign it, it doesn't matter. Do your preparation clause. That generally gives you a 1 mark. Do your heading, whether it's an application, whether it's a deed of transfer, whether it's a mortgage bond, whatever the document you want to draft. Start there. Already you've secured yourself maybe a full mark, maybe half a mark. Then you move on to your description. There always has to be a party to your deed or to your document. And I've been made to believe there's a common misunderstanding that when you're asked in a document, in a question, that you must draft a document, the misconception is that it cannot be a deed of transfer, it cannot be a power of attorney, it's almost always application. That is not true. We ask question in a real world format where the client do not give you the information as to what you must draft. When we say document or document, it can be anything. It can be a title deed. It can be an application. It can be a power of attorney. Title deed, deed of transfer, mortgage bond, it can be anything. With a description of companies, effectively when it comes to companies, after the New Companies Act, the CRC2 of 2024, it's the most important circular when it comes to companies and description of companies in all their formats, in all their formats, how they must be described. Please make sure that you know that circular. It has been amended so many times. I think there has been about at least 3 previous ones or 4 previous ones before this ultimate CRC2 of 2024. That CRC1 of 2000, it's the one that basically says the registration number of a company must have first 4 numbers that represents the year. The middle numbers must be 6 numbers, and then there'll be a suffix at the end containing 2 numbers. It's actually prescribed by that CRC, the format of what a registration number is. And then CRC1, it's in relation to trust, gives you dates from which you must put a suffix. If a letter of authority has been issued after a certain date, you must follow the suffixes there. If the suffix is given on your facts, please follow the suffix. If it's not given on your facts, look at when the letter of authority was issued. Then familiarize yourself with that CRC1 of 2028. It will tell you whether the suffix needs to be there or not. Because if you fail on that, that is going to be a rejection, because that must be followed. Another thing that is relevant to trust is that CRC3 paragraph 3 Roman figure 3 effectively says, if you're dealing with a letter of authority or a letter of executorship or a letter of appointment, refer to the wording letter of authority or letter of executorship or letter of authority. If you fail to do that the person acting is acting under a letter of authority, letter of executorship, it's a rejection. That is what that 1983 circular paragraph 3 subsection subparagraph Roman figure 3. Okay. And then that resolution 6 of 2021 says, if a person is acting under authority, you must refer to the authority. If you're acting under a resolution or power of attorney, refer to the fact that someone is acting under resolution or power of attorney. If you just say, Mapititali, duly authorized by the company, that is not in compliance with that RCR6 of 2021. You must say, Mapititali acting on authority of a resolution or power of attorney, then that is in compliance. We still get those mistakes on those, and those can be eliminated, and it prevents you from, at least it saves you some marks. We will get to the number of marks later on. Descriptions of person, particularly marriages, how they are married, unmarried, managing community of property. That CRC 5 of 1994 is still relevant. Please familiarize yourself with that. And then CRC 27 of 2013, deals with customary marriages. 1 of 2007 Civil Unions Act, and that last one is effectively about identifications, the Identification Act. But it's a very short one. We've already dealt with CRC 2 of 2009, please, particularly when it comes to that first, I think, paragraph 2 of that CRC 2 of 2009, what it says. Because the Regulation 20 says you must sign, or you must use an ink that is durable as determined by the registrar. The registrar has determined through that circular that it must be a black ink. Do not write in a blue pen. Give us an idea that you appreciate the rules in conveyancing. Some examiners exercise their discretion and say, I will penalize a bit. I will not completely disregard this paper, but that is in the examiner's discretion, and they'll dock some points, some marks. Some will, they're fully entitled to not to mark it or mark it 0 simply because of non-compliance. We've added some other regulations that you must adhere to. You must comply with when it comes to description of properties, particularly from this Regulation 27 right up to 29. Conditions, Regulation 35, Acts of Registration, Regulation 39, and a power of attorney. Remember, a special power of attorney to transfer, a special power of attorney to pass a mortgage bond. They are a form of a special power of attorney. They must always comply with Regulation 65, 3 and 4. And it's not likely that you pass an exam, you go through a drafting exam without drafting a power of attorney, generally. So you're presented with the paper. This is some of the comments we make, where advice we give, or common mistakes. Read your facts slow and make sure you understand the scenario. Bring it to life in your own mind, and then decide what documents or what is the solution. You find the candidates do not read the question paper thoroughly. They see maybe similar facts to a previous question paper. They immediately, you can see that this person read a previous question paper, then they simply answer. Read to that, to the full understanding. Make sure you satisfy yourself that you understand the question. But the rest you can go through. I just want to run through some. We still have a problem with people that don't write neatly. Keep in mind Regulation 3, Regulation 23 entitles the deeds register, the examiner in the Deeds Registries Act in the Deeds Office to refuse to register an unneat deed. Again, here, this is some of the common mistakes that tells an examiner that this person is told that, or this candidate is told that the party to this document is a close corporation. Yet they do not put the suffix 23. They come up with their own number. Just to cite an example, that clearly tells you the candidate does not understand what they are doing. They've not familiarized themselves with the practice, because you find that most of the question will say Isabel, a close corporation called Isabel. They no longer say Isabel CC. They'll just say close corporation with the name Isabel. You must now say the Isabel CC with the abbreviation CC there as required in law. But here's some of the examples, but effectively most of the companies' suffixes. Okay, and I think we've tried to make a full list of all the documents that must be witnessed. And not all documents that you draft must be witnessed, but those documents that are there must be witnessed by law. They must be witnessed. If you present such a document, you draft such a document and it's not witnessed, it's an immediate rejection. We will talk about the consequences of a rejection just now. Just make a mental note, or make a note, that number 12, on your slide, it should say regulation 39I, it's actually J, okay? And keep in mind, in 2025, early in the year, they've added regulation 39K, which will also require witnessing, and it must be lodged in a separate cover. Yeah, but you must read that with Circular 6 of 2025 that came out just last week. But that is not important for the purpose of this exam. So ignore regulation 39K for the purpose of this exam, but just keep that in mind. Now, we have picked two applications that are most common in the deeds office, okay? Which is Section 41B and Regulation 68 lost deeds. These are effectively, at least in my practice, the most common applications that you find. I've tried to compile all resolutions and circulars that relate to those applications. So familiarize yourself with those applications. For example, there are Section 41B is very easy to read, but there are so many circulars that addresses other aspects in relation to Section 41B. Because candidates tend to see the word error, they automatically say Section 41B. It is because they have no appreciation of these circulars as that are in practice that may tweak a practice or the idea that it's an error, therefore for Section 41B. So if you are able to cover all these aspects that we've discussed now, you should do well in the exam. And when you study whatever material you're using, go through the entire scope, mark out, don't skip anything, mark apart things that you don't understand for you to come back later, but go through the entire scope of conveyancing if you can. And then when you do go back only to those things that you understand. You'll almost always invariably guarantee yourself 50%, especially if you follow the simple rules. The rule is now that if your deed is rejected, or is rejectable, if English allows, your question or that question that you've answered will be marked up to 50%. Okay, that is the rule that we are both applying in deeds and in notary. This is a question that was asked, I think, last session, just to give you an idea of what we expect. I'm not going to go through all of this because we might be running a bit of time, but I'm sure you have received all of this. This is a question about descriptions of trusts. You'll see there's compliance with CRC 1 of 2018. If the candidate had not complied with that, might lose the whole mark. In general, we provide authority for the questions. The different descriptions that are for companies under CRC 2 of 2024, as advised earlier. At the time of the exam, I think CRC 1 was still applicable, but it's now been repealed by CRC 2 of 2024. Again, a different company, an RF company, how it's described. This is all as provided for in the CRC 2 of 2024. Description of parties, in the case of civil union, this is in line with that CRC 1 of 2007, and so on and so on. Other descriptions there in relation to the question. And another example, how we mark, because this is a deed, you start with your prep clause for registration. You start with your prep clause. With the amendments of the regulations, now you might put the LPC number. We still get candidates that do not put the LPC number. Leave blank space as required under Regulation 22. Mortgage bond. The fact that you put, you get a mark. You get the general idea. You know how descriptions are. Description of the parties generally vary. Marks vary between 2 marks and 4 marks, depending on whether it's a company, a person, or a deceased estate or a trust. In this case, the mortgagees were 2 entities, a company and a close corporation, duly defined. The registration number, suffixes are correct. The format is correct in line with CRC 1. Those are the things we look out for. When it comes to the numbers, it must be quoted in figures and in words as provided for in the regulations. And description of properties, see the mark allocation. And if you get one thing wrong here, for example, in this mortgage bond, you will, if it's, let me see, if it's, let's say it's out of 10, you will automatically write that question out of 5. And when we say leave out general terms, all you have to do is put the essential components in your mortgage bond and the description of properties and the necessary causa for your mortgage bond, and you should be in the clear. Consent to part payment, it must have witnesses as provided earlier. This is that RCR 6 of 2021 that says you must refer to the authority being the resolution without referring to the date or where it was signed. That is not necessary. But the fact that is, you must refer to the resolution. But if you refer to the details, you will not be penalized for that. Thank you.
Thank you, Mr. Mahwai. Thank you so much for taking us through that paper on conveyancing. I would like to just remind everyone attending that if you have any questions, please put the questions in the Q&A. At the end of the second presentation, we will read out the questions and give our presenters an opportunity to respond to the questions which would have been put on the Q&A. So if there is any question, kindly use the Q&A to pose that question. At this point, I would like to now hand over to our second speaker, Ms. Hajira Kara, to take us through the notarial exam paper. Ms. Kara, over to you, ma'am.
Thank you so much. Good afternoon. Our session today is in relation to your notarial exam. A lot of it overlaps with what my colleague has already said, but in alignment with a few things that might differ. The notary exam basically relates to the practice, functions, and duties of a notary. It's obviously divided into your different sections. Here we have our notarial practice and procedure. This area covers what a notary does, how they must behave, and the rules they must follow. It includes an understanding of your legal role, how to correctly witness and sign documents, the steps you need to follow to make a document legally valid. Also includes knowing when you are allowed and when not allowed to act as a notary. Your notarial deeds and documents, in terms of the focus areas, would be specific types of legal documents that a notary can prepare. You must know how to write these documents clearly, accurately, and legally. Your relevant legislation, this category involves knowing the main laws that affect notarial work. You need to understand how these laws apply. For example, how property law affects notarial deeds or how marital influences would affect the drafting of anti-nuptial contracts. You don't just need to know the law, you must be able to basically apply the various legislation. When it comes to ethics and professional conduct, of course, anything you practice as a legal practitioner cannot be void of the ethical dispensation. In other words, since notarial deeds have a big impact in terms of legal documents, you must be able to act honestly, with neutrality and care. Also, you need to keep proper records. So you need to be able to refer to what kind of records notaries keep. Avoid conflicts of interest, what sort of matters would give you a conflict of interest, and of course, making sure that your clients understand fully what it is that your deed entails. And like my colleague has said, when a client comes to you, they don't know everything. You're the one who advises them. So when you approach the exam and when you approach the drafting, you approach it from the point of view that this is a client who has come to you and who seeks your advice because they have been referred to a notary, but they don't know what the process is and they don't know what needs to be done. Now, this paper is usually written in the morning session at 9 o'clock. Your allocation of marks is a good indication of the time that you need to spend. So you need to read your questions carefully and plan accordingly. It's always good to use your 15 minutes reading time to properly read these questions, understand what they are about, answer the questions that you know first, and then move to the other questions. Now, if you get 50%, you have passed. If you get anything between 40 and 50, it would be an oral exam. If you're dissatisfied, you can obviously ask for a remark, and there's a process in terms of that. Now, your practical orientation emphasizes the practical aspects and understanding of the substantive law as well as the application. So this can never be separated from a thorough knowledge of the law. And just like my colleague has said, if you do not remember a section number, it is better not to write the section number in the heading of your document. You also need to understand which of these documents actually need witnesses to be noted on them, how they need to be drafted, the spacing in terms of your first half of your page. You must also be wary about the fact that your document must be something that if it's assessed by the deeds office, is it going to be a rejection note or is it not going to be? Now, again, this is in the discretion of markers, but if you are writing an answer and for some other reason, you have like a complete wrong section mentioned on it, the question becomes, did you understand what section it should have been? Or did you not understand the question? And that would then warrant a 0. You also need to take into account the fact that you need to write legibly and you need to leave a few spaces if you want to come back to a question and answer it where you've already started with a question. You need to consider your syllabus in terms of the nature and what it is that is basically covered. You must have a sound knowledge of the law and of course your practical skills. So even when there are theoretical questions, you need to put yourself in a position to be able to say, what is it that I would do in this situation? And some of the questions related to theory can be a bit more direct. Because there's only one paper for notary, you would be assessed on your practical application as well as your theoretical application. This list is not exhaustive, but it provides as a guideline for you. You need to be able to, for example, know different kinds of deeds of servitude, notarial bonds, the different kinds of bonds, when you use different kinds of bonds, which bonds are applicable to which sort of transactions, the preliminary requirements, as well as the requirements insofar as registration is concerned, the requirements in terms of after registration, the consequences of these sort of things, your anti-nuptial contracts and post-nuptial contracts, taking into account the prescribed legislation that is applicable to the different marital property regimes, your different sorts of notarial leases, your sectional title schemes, the deeds of donation, your law relating to bills of exchange, the guardianship and the marriage of minors, your matrimonial property law, And of course, your authentication of and formalities to be complied with in documents that must be declared as valid for notaries. Your preparation, formalities, and registration in terms of wills and trusts to be complied with. And your revenue laws that might affect the notary with specific reference to the different types of taxes, where you have your income tax, you have your capital gains tax, you have your donations tax, estate duty, transfer duty, and value added tax, and of course your maritime bonds and sea protests. Now, if you refer to, for example, a section somewhere in all of this, in one of your prescribed legislations, and you cannot remember the act number or the year, you can only make reference to the act by name. You don't need to know the number and the year. Insofar as describing property, you must be able to describe property in your province. So any question that you get in relation to property, you can relate the description to the property of your province, and you must know how to describe that. The golden thread of ethics runs through the whole examination, and it is important to take that into account. So when we say the golden thread of ethics, you need to put yourself in the position of what you as a notary would do. If you do draft any document, you need to, for example, refer to who it is that would sign that document. You don't need to per se have a signature on it, but you need to be able to say whose signatures would accompany such a document. You must have an understanding of the general duties and roles of a notary public, the role in society, the ethics applicable, the various principles that are applicable, as well as align this in terms of what the code of conduct allows you to do and what you are prohibited from doing. You must also understand that when you draft these questions, any references to register circulars, to the legislation and the likes of that would be referring to current legislation in a question, unless a question specifically refers to something where they give you a specific reference or a specific section in terms of which you need to refer to. And like the conveyancing, all circulars and that up to 2024 are the ones that would be applied. You are allowed 15 minutes to peruse the paper before the answering of the questions. You should not start writing in this time, but you must look at the questions, evaluate them, and see what it is that needs to be done. Try to be there early. If you're there late, you might not be able to write the exam. Once the exam is started, you will not be able to enter 30 minutes after the commencement. And once you are done, you must, of course, hand in your full examination booklet. If you have more than one booklet, please ensure you number them accordingly. You also must take into account that you must try not to cramp. You will not be able to learn sections and regulations and things overnight. Make summaries if it works for you. You need to practice your drafting. You need to also eat well. You need to drink water, stay hydrated. You need to take short breaks, prevent yourself from any fatigue. And of course, it's not a competition as to what time you finish and how long you're studying for. It's about you understanding the content and what is needed from you. You must also take into account that you must not only rely on past papers, because like my colleague has indicated, you sometimes absorb a question in a past paper and think this is the same question because something looks familiar, and only to realize that it is actually not the same concept that is being tested. Try not to leave blanks. Try to answer questions where you attempt them and you at least fill in something. Use a black pen. Write only on one side of the page. You cannot write on the left side. It's not going to be marked. Pencil is not going to be marked, and neither is correction tape going to be marked. So if you correct anything with correction tape, it's not going to be marked. So be wary of that. Also, where you have multiple paragraphs, or like there's sub paragraphs in a question, number your questions correctly. Write legibly. It's a problem if you do not write very legibly. Beware even of your cross references. You might be drafting something where you're referring to something above, but you have lots of sub paragraphs, and we don't know which paragraph it is that you are referring to. You also need to think practically. So if you are drafting a document, the sequence in terms of which you are drafting. So you need to think practically about it in the sense that you cannot, for example, put a preparation at the end of the document and then think that's where it needs to be, or you have it somewhere where, but it's not in place of where it has to be. What we know about drafting these documents in terms of your notary is that certain things must follow in a certain consequence, and that's how they need to be drafted per se. You are also advised that you need to look at the various legislation that is applicable in terms of notarial documents and how these affect your drafting of your documents in terms of, for example, status, the different types of matrimonial property regimes, what sort of marriages are they, and how do you refer to those marriages in terms of your drafting. You also need, and all this coming from the Chief Registrar Circular, as my colleague has referred to. And you must also take into account that when you are drafting an answer, your mark allocation must guide you on the number of documents you need to draft, as well as on the on the documents that you need to draft. Now, the mark allocation is one thing, and we don't always know how marks are broken down. But when you get a question and you evaluate it, take into account that this is my client has come to me only with the identity documents or the relevant documents that they have. I need to advise them and I need to draft the documents as fully as I would if it has to go for registration, or this is what a notary would do. So read your questions carefully, look at what needs to be drafted. Sometimes a question has multiple documents that need to be drafted. So read it carefully, look at what the question is saying, look at what it says in terms of answering and how much is required of you. And take that into account. You are not provided with anything other than your answer booklet. So you are not going to be provided with any forms, any precedents, or anything the like of that. So be wary of that, because you will have to draft everything and you must refer to relevant legislation all on your own. And that's it. That is the what your notary exam would basically be about. And we wish you all the best and study hard. Thank you.
Thank you so much, Ms. Kara. Would now like to move on to the Q&A section. And I'd like to hand over now to my colleague, Mr. Letlogonolo Molefe, to go through the questions and comments that have been posted on the Q&A. Before you take over, Hloni, just a reminder that the recording will be made available on our YouTube channel. The recording will be made available, and we are aiming at having that available on this coming Monday at the latest. Thank you very much. Over to you, Hloni.
Good day, colleagues. Am I audible?
Yes, you are.
So the first question in the Q&A are bills of exchange still relevant for the purposes of the notary exams? That's the first question.
So basically, we have certain documents which do fall under your bills of exchange. Those that are no longer functional would not be part of it, but for the rest of it, yes.
And then there's another question: will the Deeds Registries Act, Sectional Titles Act, and Regulations forms be provided for the notarial exams, like with the conveyancing exam?
No, you don't get any additional material except your question paper and your answer booklet.
Another question is, where the first half needs to be left open, do we just write top part to left open to show that it must be left open, or do you physically leave a blank space?
If I can come in there, if you write it down, it will show that you know and you appreciate the provisions of Regulation 22, and then that would be sufficient. That is 20 subsection 2.
Okay, and then the next question from the Q&A, if the question does not specify that we must omit the general clause in a bond, like 2023 April question 4, what is expected from the candidate?
I would draft all the essentials and mention the general terms and show that you require them. But also look at the mark allocation. If your mark allocation is only 5 marks, I think the essentials are only required. If it's 40 marks, you might just have to deal with the general provisions.
Okay, and then the next question is, we describe the property as per our province, even if the question states it for another province. That's another question.
As long as the candidate appreciates the provisions of section regulation 27, 28, and 29, and they practice in their own province, you will not be penalized because you have a different province. But there are specific requirements as stated in regulation 27, 28, and 29.
Then another question is, are resolutions and circulars issued in 2025 applicable to the exam?
No, they are not applicable.
Okay, and then there's another question. With regards to paper 2, can we draft all questions for the lodgement in the deeds office applicable to the province in which we are writing?
It doesn't matter as long as you comply with the description of the deeds office. If I remember, please, Amanda, correction here. CRC 3 of 2024 provides all the necessary description. I'll just double check that now.
Okay. Then another question is, when answering short questions, would we be penalized for writing in point form?
Sorry, say that again.
When answering short questions, would we be penalized for writing in point form?
No, you will not be penalized for that.
Here's another question. If the property is in Johannesburg, on the facts, can I use the KZN description? Would I be penalized?
No, you will not be penalized for that.
Then do we only need to know the property description for the province where you are writing? For example, if the question says the property is in Cape Town, okay, I think this is a repeated question, but we're writing in Johannesburg, can we say registration division province of Gauteng?
As long as it complies with the regulations as provided in 27, 28 to 29, it will be sufficient. But don't use a Pretoria description and then at the end you have your registrar be that of KwaZulu-Natal.
Okay, another question is, can't you confirm which paper is written first, theory or practice?
Sorry, say that again?
Can't you confirm which paper is written first, theory or practice?
The drafting paper 2 is written first, but I think it's stated on the notification by the LPC.
Okay. Are the latest question papers for the April 2025 available on the LPC website? Mr. Ditebele, I think we did post it should be available on the website under notices and advisory. Okay.
When we send out the link to the video, we'll also reattach the syllabus again.
Okay. For the exams, reference is made to form. Is it forms that will be provided with the paper of, or should own forms be brought into the examination venue?
The forms are provided for in that booklet that the LPC gives to all the candidates in the exam. The sectional titles and deeds registered on all the forms are usually provided there.
Okay. And then this is the last question on the Q&A section. Good afternoon. The syllabus on the website is just the one for April 2025. And when will we receive confirmation of venues we will be writing at? We are in Cape Town and haven't received anything. When will we receive it?
That is not in my area.
I think we'll. And then there's some questions from the chats. I'm just going to the chat section now. So the question from one of the from the chat section: if we are asked to calculate transfer duty, can we use the current rates as per 1 April 2025, even though these rates came into effect in 2025 and the exams are set with regard to the law at the end of 2024?
One must be very precise and careful with that question specifically, in that most of the time a date is provided, the date of transaction is provided. The rate applicable will be determined by the date of transaction. If the date is not provided in the question, that is the date of transaction, then you use the current rate. If, for example, you are aware of the current rate and use a previous rate, indicate on your question which rate you're using.
Okay, then the next question from the chat section is, do we have to know the property descriptions for all deed registries or just the area where we're writing? I think,
Only for the area where you are writing.
Okay. So there are two questions here from the chat section. Which scales are applicable or must we use this in this exam? That's the first part. And then when questions or facts are silent on VAT, do we have to calculate it?
Sorry, just ask the question, especially the first one. What scale are we talking about?
Which scales are applicable or must we use in this exam? And then point number 2 is when question or facts are silent on VAT, do we have to calculate it?
The VAT one is easy. So if a question is silent on VAT and in line with the syllabus, Section 64 of the VAT Act is very clear on what must happen. The candidate must go and study that section. The first part, I'm not sure what scale we're talking about.
Okay, then the next question, if the question does not specify that we must omit to the general clauses in a bond, like 2023 April question 4, what is expected from the candidate?
Yeah, we've already answered that in the Q&A.
Answered that one in the Q&A, yes. Okay, this is speaks to one the syllabus. Here's a question. For conveyancing, must we know the specific practices for each deeds office throughout the country? For instance, Cape Town has a pivot deed system. This, I assume, we must know, like the Freiburg, where there are specific practices followed and then gain something different in Nelspruit and in another jurisdiction.
For the purposes of exam, no, it's not necessary to know unique practices of a certain deeds office. You will not be tested on unique practices of a local deeds office.
Okay. Then the next question, in questions relating to drafting of the notarial deeds, when a question says draft the documents, does it refer to one document or there is a possibility that you have to draft more than one document?
So we've addressed this in the presentation. What it basically means is when it says draft the document or documents, you need to look at what documents it is you would have drafted. And unless a question specifically tells you which document to draft, you are expected to draft everything that you would have drafted if this client was in your office.
So the next question is, what does it mean when it is said details, especially the description of properties, may be changed to comply with the practice prevailing at your deeds office? This appears on the question paper.
I just ask that again.
Okay. So the question is, what does it mean when it is said details, especially the description of properties, may be changed to comply with the practice prevailing at your deeds office? This appears on questions paper. Well, it appears on question papers, yeah. I think that's what they were trying to say.
It's a description of the deeds office or of the property.
Deeds office.
Yeah, no, that is again in line with the description in that the description of deeds office is in the Circular 3 of 2024. So because it's relatively new and there's a renaming of deeds registries, the candidates must familiarize themselves with that CRC 3 of 2024.
Okay, another question: if an exclusive use area is erroneously registered to 2 people, do we need to cancel both EUAs or first and then register to the correct person, or do we just cancel the incorrect EUA only?
That sounds too specific for a general prep exam. I don't know the context of cancelling that exam, but I think that is more a studying question than the preparation for exam.
Okay, the next question, how do we prepare a statement of account for parties?
For parties?
Yes.
Again, that's about content. I would have to then show someone credit and debit and credit on here. That's not the purpose of this meeting. There's a number of examples. Any law firm will show you how to draft a statement, or your notes will show you how to draft a statement.
When qualifying conditions, do you start with the common conditions or can you mix them?
When qualifying condition, again, it's on contents, but regulation 35, I think it specifies what you must do when it comes to conditions.
And the next question is, the names of the deeds registry's office have recently changed. Do we need to refer strictly to the new names, or can we still use the old names?
You must use the new name. Again, that circular keeps popping up again. CRC 3 of 2024. You must use the new name.
Okay.
You will be penalized for that.
Will the act be provided for 2024 or 2025?
So will what?
Will the act be provided for 2024 or 2025?
I think it's 2024 that is provided.
Okay.
In any way, the questions are drafted up to 2024.
And then for the notarial practice, must we know how to describe a property in all the deeds offices? What do you do if the question says that you are a notary practicing?
So you will draft the description for the province in which you are writing. If the question says you are a notary practicing, it means that they're referring to you practicing in the province where you are writing.
Does an incorrect description of a party automatically make the question 50%?
Sorry?
Are we going to, does an incorrect description of a party automatically make the question 50%?
Effectively, yes. And what that means is not that you will get 50%. You can still get marked down. So if I understand the question correctly, if you get your description of your party and it's liable for rejection, if it's liable for rejection, therefore you're writing that question specifically up to 50% of the total mark of that question. And then if you still get other things wrong, you will be marked down further.
For the notarial practice, are we expected to know all municipalities in all the provinces?
No, but you must know the province where you are writing. You must know how to cite that.
Yeah, that's all the questions, because some of the questions have been repeated already from the question and answer side.
The The candidates, if they allow, may still send you, email you questions. I'm willing to answer them by email to you guys.
Thank you, Mr. Honolo, for taking us through the Q&A, and thanks again to Mr. Mahwai and Ms. Kara for responding to the questions. Before we close the session, I'd like to maybe just give a moment to Mr. Mahwai and Ms. Kara for their final thoughts, final tips, or any final comments before we close the session. Mr. Mahwai, may I start with you, sir? Any key points you just want to re-emphasize regarding the exams?
Let me see. I think I made a few notes. Let me see if I've covered them. I know the questions are long, but try your best to, at the beginning, that 15 minutes, while you're reading the question papers, allocate minutes, time you will spend on each question and divide them accordingly. And again, start with the ones that you are certain of first. Don't try to go through them by order. If you have a statement, start with the statement, please. Thank you.
Thank you so much, Mr. Mahwai. Ms. Kara, if I may hand over to you for your final thoughts, comments, and tips on the exam.
Thank you. Go through your work thoroughly and don't spot. Don't spot, because the spotting is not going to assist you in evaluating how to apply the theory to the practical. Try to draft your documents as fully as you can, and understand how to cite a party or how to cite a property in the municipality and that in the province where you are. Again, if you don't remember a specific section or application, maybe just leave it out when you are drafting and just refer to it as an application, and try to answer all the questions. And I wish you the best. Thank you.
Thank you so much, Ms. Kara. If there are follow-up questions, please email them to info@lpc.org.za, info@lpc.org.za. Please make sure that the title or the subject is exams or conveyancing or notarial, something along those lines, so that my team is then able to share them with Ms. Kara and Mr. Mahwai, and with the education department to respond to your follow-up. On that note, I would like to say thank you to our presenters this afternoon. To you, Mr. Tumelo Mahwai, thank you so much, sir, for taking us through the paper. And to you, Ms. Kara, thank you so much, ma'am, for taking us through the notarial paper as well. To you, candidates writing exams, good luck, all the best, and we trust that you found the session to be helpful. Again, if there are any follow-ups, do send us an email and we'll do our best to ensure that you get the response. Have a wonderful afternoon, wonderful weekend, and all the best with the exams. Thank you very much.